The Liberty Weekly podcast is brought to you by Tom Wood's Liberty Classroom. Sick of losing arguments with your statist friends? Fear no more. Now you can vanquish your intellectual foes with courses taught by top libertarian professors. Tool your intellectual arsenal and enroll today by navigating to www.libertyweekly.net/Liberty Classroom or by following the link in the show notes page.
All the voting that has ever taken place under the Constitution has been of such a kind that it not only did not pledge the whole people to support the Constitution, but it did not even pledge any one of them to do so, as the following considerations show. 1. In the very nature of things, the act of voting could bind nobody but the actual voters. But owing to the property qualifications required, it is probable that during the first 20 or 30 years under the Constitution, not more than 1/10, 15th, or perhaps 20th of the whole population, black and white, men, women, and minors, were permitted to vote. Consequently, so far as voting was concerned, not more than 1/10, 15th, or 20th of those then existing could have incurred any obligation to support the Constitution. At the present time, it is probable that not more than 1/6 of the whole population are permitted to vote. Consequently, so far as voting is concerned, the other 5/6 can have given no pledge that they will support the Constitution. Legally speaking, the act of voting utterly fails to pledge any one of them to support the government. It utterly fails to prove that the government rests upon the voluntary support of anybody. On general principles of law and reason, it cannot be said that the government has any voluntary supporters at all, until it can be distinctly shown who its voluntary supporters are.
Hello and welcome back to another episode of the Liberty Weekly podcast. I'm your host, Patrick MacFarlane, appearing solo today. That is without my co-host, Jerry McCullum, who at the time of this recording is still recovering from his vacation. So I was planning on releasing a Thought Crime Thursdays episode this week, but somewhere between all of my classes starting and, student org commitments and reconnecting with law school friends, I couldn't really find the time to do the episode justice, this is my episode about Brave New World that I've been working on for 2 weeks now. So I just wanted to make sure that when I finally do release it, it is of the quality that you would come to expect from this show. But before we get started here with episode 28, which is about Lysander Spooner and the Constitution of No Authority, I wanted to announce that concurrent with the release of this podcast episode, I will be launching the Liberty Weekly Patreon page. And there we have several tiers of membership available that will bring more value to the podcast and will also give you, the listeners, greater access to the show. And so just to briefly detail the tiers that we have here, the first level is called the Marginal Utility Level Access. And with that, you would get access to our secret Facebook community featuring direct contact with myself and other Liberty Weekly listeners, access to hyperlinked transcripts of all the scripted shows that we do, and copies of our free ebooks, of which you've probably heard about already on this show if you're a regular listener. And the second level of access at $5 or more per month is called the Ludwig von Mises access, if you'll excuse the puns here at the tier levels. This level includes all the above rewards plus access to the Liberty Weekly meme repository, which is curated and created by myself, but curated also with additions from the actual Anarchy guys and members of our secret Facebook community. And the next level is called the Murray Rothbard level access at $10 or more per month. You get all the above rewards, plus access to bloopers, extras, and warm-up recordings, of which I've compiled a bunch since we started the podcast, so that will all be released as well. And plus, at this level, which is, again, $10 per month, you get access to a monthly subscribers-only State of the Show podcast, where I kind of talk about what's going on and what my plans are for the future. And the next level is called the Enemy of the State level access. It's $20 or more per month. And at this level, you get all previous awards, plus early access to unedited audio when it's applicable, when we do a discussion style show or when we do a show with a guest or something like that. Plus one redeemable guaranteed show topic suggestion. And so if you enter this level, we will guarantee that we will do a show about the topic of your choosing. At the next level is called the Mysterious Benefactor level access, which is, I have the Koch brothers in parentheses just as a little poke at the LP. But that level includes all of the above rewards, plus executive producer credit at the end of each episode, and a handwritten thank you letter from co-host Jerry, myself, and my wife, who would also be benefiting from any patrons that we get on Patreon. And that level is $50 or more per month. And the last level is called the McNuke level, which is $100 or more per month. And I've limited that to 2 patrons, just because the reward there includes joining us on the show once every other month to talk about, whatever you want to talk about kind of stuff. And so those are the levels. If you guys value the work that I do here and that Jerry does here, we would definitely urge you to show your support by becoming a patron to the show. Obviously, you get some goodies in exchange, but it would also benefit you in giving us more incentive to do better work and to produce more value for you. So we have that there. And I almost forgot to mention, you can find our Patreon by navigating to patreon.com/Liberty Weekly. And one last thing, before I get into the meat of this episode, I want to let everyone know that as the podcast is getting more and more technical, it will be more and more important to reference the show notes, which may be found by navigating to libertyweekly.net/the episode number of the show. So correspondingly, this show is episode 28. You would find the show notes by navigating to libertyweekly.net/28. So with that, let's dive into this week's topic, which is Lysander Spooner and the Constitution of No Authority. So last week in episode 27, I released a biography episode about Lysander Spooner, and that episode was a pilot or a test run of sorts for a more scholarly and scripted podcast format. And after publishing, I'm glad to say that I got a lot of positive feedback for the episode. And additionally, I realized that people really effing love Lysander Spooner, which is awesome because he's really cool and obviously he's done a lot of really good work. And so I wanted to continue with that theme of studying his work in this podcast episode. So to continue my coverage, this week we're going to be talking about what to many ANCAPs or voluntarists is his most well-known and useful piece, the Constitution of No Authority. And in fact, Murray Rothbard himself has labeled this essay, quote, the greatest case for anarchist political philosophy ever, period, end quote. Just to advertise our Patreon a little bit, I'm reading right now from our script. With the basic level access, you will get a copy of this script that is hyperlinked to all the assertions that I make there. So I quoted Murray Rothbard. I linked my source material right there. And to get back to the show, what I wanted to say is I'm not going to be summarizing the document, the Constitution of No Authority, but my intention is to supplement certain points that I think Lysander Spooner kind of glosses over a bit, and that's mainly that the Constitution would not be legally recognized as being a valid contract, and if the Constitution is a law and not a contract, it does not comport with its own theory of popular sovereignty, which is the very foundation upon which it is built. So to say that again, I'm not going to be summarizing the Constitution of No Authority. I'm just going to be trying to supplement it a little bit here. So before we get into it, I want to give a little background on the Constitution itself. So first, I wanted to ask the question of what is a constitution? And so like any good attorney or law student, I went first to Black's Law Dictionary, which defines a constitution as, quote, in public law, the organic and fundamental law of a nation or state, which may be written or unwritten, establishing the character and conception of its government, laying the basic principles to which its eternal life is to be conformed, organizing the government and regulating, distributing, and limiting the function of its different departments, and prescribing the extent and manner of the exercise of sovereign powers. And I've highlighted that because that phrase, exercise of sovereign powers, is very important going forward here. It's important to note as well that this Black's Law Dictionary defines a constitution as a fundamental law. But I think that in this sense, Black's Law, the definition that it's offering is more descriptive than it is prescriptive, and that's just a criticism that I have here. Traditionally, tracing back to the Magna Carta, the purpose behind a constitution has been to limit the divinely ordained power of the monarch or governing authority. In exchange, or so the theory goes, we are to forego certain liberties in exchange for the government's protection. Now, the prevailing theories of the Constitution, or what you learn in constitutional law class in law school, is that the Constitution was ordained either as a contract or a law, either between the states who created the federal government with the power of their citizens, or that the people themselves bypassed the states and contracted and created directly with the federal government. So either the people created the federal government directly, or they did it through the states who acted as their agents. And I think that if you spend any time looking at Jonathan Elliott's first-hand notes and transcripts from the ratification debates, and from reading the Federalist Papers, it becomes rather clear that the states contracted to create a federal government, that the states acted loosely as the agents of the people to create the federal government, which was granted explicitly enumerated powers for certain specific purposes. And I think there's no arguing to the contrary of this interpretation without either warping history or lying by omission. And this is something that I've written papers about in law school. So if the Constitution is valid, that's the correct interpretation, that the states acted as the agents of the people, taking their popular sovereignty and created a federal government between the states as a creation of the states. So before ratification, we have the Anti-Federalists, people like George Mason, Patrick Henry, James Monroe, and Samuel Adams. And on the other hand, you have the Federalists, who are pro-Constitution and pre-Constitution, because there's two groups of Federalists. We'll get into that. Some of them are good guys. Some of the Federalists who wanted the Constitution ratified were good guys, like James Madison. And some of them are bad guys, like John Adams and Alexander Hamilton. Now, after ratification, the Anti-Federalists morph into what would become known as the Jeffersonian Democratic Republicans. That is to say, pretty much all of the Anti-Federalists, those who opposed the Constitution's ratification, end up turning into Republicans. But then you have some people that originally supported the Constitution who also leave the Federalists and become Republicans, and those are people like James Madison and others that I had mentioned before. Essentially, they realized that they were pro-Constitution, and they were Federalists before ratification, but then after ratification, they realized that the core of the Federalist Party had begun to break their promises insofar as what they had sold the Constitution to be. So, people like James Madison wise up and they leave the Federalists for the Democratic Republicans. And this is happening in the 1790s, very soon after ratification happens in 1789. So after this split and reformation of political lines, things start to unravel a bit. And this begins with Alexander Hamilton's First Bank of the United States. Then it moves on with the Alien and Sedition Acts. And then it really picks up speed through Marbury v. Madison, where the Supreme Court finds, not incorrectly though, that it has the power to interpret what the Constitution means and use this power to declare federal laws unconstitutional and strike them down as null and no effect. Now, by itself, this isn't necessarily a problem, because before Marbury v. Madison, state courts did, in fact, use judicial review, and that's what it's called, the legal doctrine, to strike down acts of their state legislatures. However, their decisions recognized what in legal jargon is called the clear case doctrine. If a law clearly and undoubtedly violates the state constitution, it was to be struck down through judicial review when the state Supreme Court took a look at it and found it unconstitutional. Now, on the other hand, if it was a close call, then the decision was not for the judicial branch to make. It was to go back to the people. So if there was a law passed by the legislature and it was a close call as to constitutionality, you were supposed to give the benefit of the doubt to the people, because through this theory, the people manifested their will in the legislature. So it was a matter of a political question, not for the courts to decide. And this precedent was established in the state courts, was the clear case doctrine. On the other hand, when it gets to the federal level in Marbury v. Madison, John Marshall, the first Chief Justice of the Supreme Court, leaps at the opportunity to establish the power of judicial review, which again was not beyond the scope of the court, but he does so without following the common law clear case doctrine, which had already been articulated in numerous state court decisions. This opens up basically the door to federal encroachment, which is mechanized by the Supreme Court and powered by willful misinterpretations of the Supremacy Clause, the General Welfare Clause, the Necessary and Proper Clause, and a Supercharged Commerce Clause. And as well, it has to do with the 17th Amendment, which establishes the direct election of senators, the popular election of senators. And so, coupled, all those things combined throughout the decades to expand federal power under the Constitution. But the true death of the original interpretation of the Constitution and the death of the spirit of the Declaration of Independence, which is self-governance, occurs through the demise of the Confederacy. And that is not necessarily to say that the Confederacy was a perfect embodiment of the anti-federalist principles, but merely that the historical and political process of the war to prevent Southern secession eviscerated the founding principles finally and once and for all. And it is this transition and in this climate that Lysander Spooner decides to write No Treason. Now, as I have alluded to, following the Civil War, Spooner was alarmed with the encroachment of big government under the Lincoln regime, with the destruction of the South, and the evils of Reconstruction, and all the familiar trappings of big government. And, think of things such as the special favors to railroad monopolies, Lincoln's suspension of habeas corpus, the war itself, the jailing of critical journalists, and General Sherman's march to the sea, and the tariff of abominations, all those different things that led and happened during the Civil War. And as a side note, I would refer the listeners to read books like The Real Lincoln by Thomas DiLorenzo, with the skeptical eye, side note. And moreover, I would recommend that you read a book called Emancipating Slaves, Enslaving Free Men, which I've heard from several people is the best book to read if you're someone like us about the Civil War. So we have Lysander Spooner concerned about these things and the encroachment of big government. And despite being a fierce abolitionist, and I say this because today we associate abolitionism with the Union. Despite being an abolitionist, he decides to write the No Treason pamphlets in support of the South and their attempt at secession, basically arguing that secession is, quote, no treason. And just to let you guys know, I do plan on doing episodes on the other essays in due time, because No Treason was a collection of 3 essays, and I want to cover all of them. But obviously, the Constitution of No Authority is the most well-known, so I'm doing that one first. But as the listener will recall from our last episode, the Constitution of No Authority is actually just one essay in a collection of 3, as I just said, published by Spooner under the title No Treason. And so individually, the 3 are titled number 1, No Treason, number 2, The Constitution, and number 6, The Constitution of No Authority. And these were published in 1867, 1867, and 1870, respectively. And for reasons unexplained, essays number 3, 4, and 5 were never written. But before and during the war, as we know from last week's episode, Lysander Spooner was a radical abolitionist that advocated the arming of the slaves so that they could battle slave owners to resist their physical capture in a type of guerrilla warfare, not unlike what was inaccurately portrayed in the Free State of Jones. And in fact, we learn in the last episode that Spooner and his wealthy activist benefactor Gerrit Smith may have been involved in fomenting the raid on Harper's Ferry and had met with John Brown before the raid itself took place. Remember, John Brown, after the raid, is captured, imprisoned, and executed eventually. There's also evidence to suggest that Spooner and Smith had taken steps to execute similar events that failed to materialize. Anyway, Spooner begins the essay by saying that the Constitution has no authority or obligation except as a contract between man and man. And so right away we have to articulate what Spooner means here, because statists will just present the prevailing theories that I mentioned earlier. They will either say that the people contracted with the federal government through the states, or that they did it as members of a new federal nation. Either way, they're making a leap of political faith here. They're implying that vague political entities may create a contract that binds not only everyone living within its territorial bounds, but also their posterity indefinitely and with no termination clause. And the whole point of this is that there's a double standard here. We don't treat the political sphere with the same type of scrutiny and legitimacy as we do the private sphere. And so we're going to be talking about that difference here. Now, some might just make the argument that the Constitution is not a contract and that it is a law. In fact, Black's Law Dictionary did that in the definition I read earlier. So before we rip apart the notion that the Constitution created a legally binding contract, let's address that argument, that it's a law. So if we are addressing the argument that the Constitution is a law, let's pose the question, where does law come from? Now, this is certainly a big question. It is generally said that the law itself comes from tradition and time immemorial, from the way that society has organized itself and solved conflicts for millennia. And this would be, just a type of spontaneous order, actually, which is very ironic. But it has been said that the law comes from these millions and millions and trillions of different controversies that arise between, and the law comes as the solution to these controversies. And then we derive, rules and laws from the strings of decisions. That's called the common law. But more tangibly speaking, in our modern system, law comes from two places, either from a decentralized string of independent decisions, what I just described, which is called the common law system, or from centralized sources like a legislature. And examples of this are the U.S. Code or other state statutes. That is called a civil law system. And so usually when civil laws are drafted, they are fundamentally based on principles that at one time or another came from the common law. But ultimately, the law that is this civil law is dictated by one body, like a legislature or the EU. So in the United States, our general legal principles are derived from the English common law system, but most of our laws that we have to abide by are drafted and passed by the legislature and codified in state and federal statutes. And of course, under a government, both sets of laws, both civil and the common law system, are imposed upon us coercively, because the government has secured a monopoly on the judicial system through their monopoly on violence. However, fundamentally speaking, the civil law system is the only one that is dictatorial by its very nature, because the common law system is decentralized and comes about through judges making independent decisions by applying precedent to immediate cases affecting only the immediate litigants and the future courts that will rely on their decision on the precedent set in each given case. On the other hand, legislatures just make stuff up based on their own personal and political whims and then apply it to thousands of people they've never met. And there's ways that they can try and derive, what the people want, I guess, through, doing research or statistics or stuff like that. But we know how well that works, which is not very. Now, although the Constitution is based on common law principles, it is fundamentally a document that was created by the constitutional conventions and ratified by the state legislatures independently. It is fundamentally derived from the dictates of a legislature, and therefore I would argue that the Constitution itself is a construction of the civil law system because it was dictated by a legislature. Now, to illustrate why the Constitution is fundamentally invalid both as a law and as a contract, it is necessary to illustrate the difference between how things operate in the private sphere as opposed to the public sphere, first by tackling the Constitution as a law and then by tackling the Constitution as a contract. So if the Constitution is to be a law, its very text implies that its power and authority is derived from, quote, the consent of the governed in what is called popular sovereignty. That is the idea that the people themselves hold the ultimate political authority in the country, in our system. And this is the foundation upon which our entire governmental system, the whole American project, is based on this idea of quote-unquote popular sovereignty. Now, in order for this to work under the Constitution, the people's popular sovereignty is given to the state governments, and the state governments, in turn, take a portion of that popular sovereignty derived from the people and give it to the federal government. And under this fairy tale, the will of the people to create laws is manifested in the state and federal legislatures where they are, quote, represented by politicians. To show that this whole thing is just bogus and that popular sovereignty is inferior to individual sovereignty, I'm going to hand the reins off to Professor Tom Woods for a second to illustrate the difference between the concept of, quote, representation in the private sphere as opposed to in the public sphere.
Are political representatives the agents of the people they represent, and thus are required to carry out the people's will? If you are my agent, you carry out my will. That's what an agent does. And on the next slide, we'll talk about representation in non-political situations. We'll talk about what an agent typically does. So is my politician, is my political representative, is he my agent, and he's bound to do what I want him to do? Is he rather a trustee who can act according to the best interests of the people they represent as they see those interests? So is my representative a trustee who will carry out my best interests even if I myself don't see them? Even if I myself think my interests are A and he thinks my interests are B, does he have the right to go ahead and pursue interest B? When I think my interests are A and I'm just mistaken, can he in effect correct me and go ahead and pursue my interests as he sees them? Or are political representatives essentially free to do anything they want? What is the correct answer here? Well, let's complicate matters by having me give you some examples, some scenarios involving representation. And as I'm doing so, I want you to think about whether this resembles what a political representative is really doing. These examples come from Professor Gerard Casey, who's a professor in the Department of Philosophy at University College Dublin over in Ireland. So here's the first example. I am unable to go to a meeting of the committee of my local residents association. It is an important meeting where decisions of some importance are going to be made. So I ask my wife to go along in attendance, subject to the consent of the meeting. I inform her of my views of the important matter under discussion, and when it comes up, she puts these views forward as being mine. In these circumstances, she represents me. Now consider the second example. An issue is coming up for decision in the higher echelons of the university. A discussion takes place at a meeting of the Department of Philosophy, and a general consensus emerges. The chair of the department is mandated to make the department's collective view known to the powers that be. In these circumstances, the department chair represents the department. Here's another example. I want to buy something at an auction, but I do not want to appear there myself for fear of raising the price. I hire a destitute and needy graduate student to purchase a painting for me. I give him explicit instructions on the price. He does exactly what I have commissioned him to do. He represents me for this specific transaction. Another example. I grant power of attorney to my lawyers with general but not completely elastic instructions. As long as they remain within the remit of those instructions, they represent me. This one. Johnson is my local member of parliament. I did not vote for him. I do not agree with any of his views. Does he represent me? This one. Robinson is my local member of parliament. I did vote for him, not because I actively desired his election, but because I wanted to prevent the election of an even more disagreeable candidate. As it happens, I agree with some, but not all of his views. Does he represent me at all times, or only when his actions conform to my views? All right, now let's examine representation in non-political situations. In other words, where there's no civil government involved. Now, in this diagram, you can pay no attention to asymmetric information. You can ignore that. But in non-political situations, when we talk about representation, we say, I have a representative. We're often thinking in terms of a principal-agent relationship. An agent is somebody who is responsible to the principal and must pursue the principal's interests. So let's think in terms of maybe a musician having an agent, or maybe an author having an agent, because I've had that situation. I have a literary agent. The agent is supposed to pursue my interests. He's supposed to do what is best for me. And if I tell him not to do a certain thing, he can't do it. If I say, do not accept that contract with Random House, although happily I've never had to say that. I've always accepted a contract from Random House, but if I were to say that to him, then he would be obligated not to accept that contract. And if I say, I'd like you to pursue this contract, even though he may think it's not as favorable as the other one, he is obligated to do it. He has to pursue my interests, and indeed he has to pursue even specific actions that I ask him to carry out. Now, in the case of political representation, the idea would be that you are the principal, and the politician, the member of Congress, is the agent. So in the previous case, obviously, I was the principal, and the agent is the agent. But in politics, the idea would be that the voter is the principal, and the representative is the agent. But in that case, as we see in politics, clearly the agent is not responsible to the principal, because clearly the political figure is always doing things without ever consulting you, right? And you have no way of saying, hey, you can't do that. You can't do that. I forbid you to do that. I order you to do something else. How could you do that to your U.S. congressman? You'd have no way of doing that. Not only that, the principal in this case is not just one person. It's not like you're the only voter and you voted for this congressman. There are many voters, so therefore there are many principals. And the vast bulk of these voters, the agent doesn't even know most of these principals. So how can he possibly represent them in the sense that we think of representation in normal speech, normal non-governmental speech? When we're talking about representation in any other situation, as a normal person thinking about representation, how could he do it? How could you represent 500,000 people you've never met? How could you do it? And none of them have the power to tell you to do or not do anything. Well, then what does that mean, that you are a representative of those people?
So by comparing the magical world of government to the real world that we plebs are all resigned to, we can see that if the Constitution is a law, it does not comport with what we could objectively identify as legal representation in the private sector. Now, even if we were to give the same amount of reverence to the concept of popular sovereignty as opposed to individual sovereignty, Lysander Spooner points out that, and I quote, "Furthermore, we know historically that only a small portion even of the people then existing were consulted on the subject of the Constitution, or asked, or permitted to express either their consent or dissent in any formal manner. And I'm not a fan of democracy, but, quote, popular sovereignty implies the popular will of the people. If only 1/10 of the people then existing, or 1/6 even, of those existing then in the United States voted for their state representatives, who then in turn voted for their state to ratify the new Constitution, I don't really see how that would be a true expression of the popular will that would truly satisfy the theory of popular sovereignty upon which our entire government is built. And true, the Constitution created a Republican form of government, and that a Republican form of government was in fact established in the United States and did exist in the United States. Popular sovereignty implies the popular will of the people, and if popular sovereignty sounds like a democratic ideal, like just a numbers game, and if you're playing the numbers game, 1/6 of the people voting to ratify the Constitution, it could have even been less. 1/6 is a conservative estimate. If 1/6 of the people voted for their state legislatures who were supposed to adopt the ratification of the Constitution, the numbers just don't imply popular will. Between the shortcomings of political representation and the historical facts laid out by Mr. Spooner, the Constitution, insofar as it was a piece of legislation that relies upon the theory of popular sovereignty to derive its authority, is invalid. It just doesn't work. So to this point in the episode, I've attempted to illustrate that the Constitution is not binding as a law because the popular sovereignty upon which its foundations rest is not manifested in the creation of the document itself. So next, moving on, we'll turn to Mr. Spooner's main argument that the Constitution is only legally binding as a contract between man and man. And to frame this point, I want to pose two basic questions. 1, what is a contract anyways? And 2, is the Constitution a valid contract? One thing that people may not realize is that contracts are not just some amorphous concept. They are actually backed by an entire body of law containing lots of nuances and certain legal principles. And I don't say this to be condescending, but many people really have no idea what a contract is, or they have no idea that there's an entire body of study behind it, and rigorously so. But for the purposes of defining contracts, I will be referring to the 8th edition of Contracts in a Nutshell by West Academic Publishing, which is a very popular outline and very popular, we call it a horn book, that law students will study to familiarize themselves with a certain area of the law. And the Contracts in a Nutshell series is a popular one that is used in law schools across the country. So in the first year of law school, you learn, legally speaking, that a contract is a promise or a set of promises for the breach of which the law gives a remedy. And I'm quoting there. Often these promises are evidenced in writing, but can exist without writing if the elements of a contract formation are met. It so follows that fundamentally contract law is concerned with enforcing objectively identifiable promises. To the listener, it should be self-evident why any organized society would create a system for enforcing promises. Fundamentally, contracts form the very basis of any advanced economy. As libertarians, we see freedom of contract as a fundamental right. Following natural rights theory, we can see freedom of contract arising from property rights, i.e., I own myself and the fruits of my labor. Therefore, I can enter into legally enforceable agreements with others for their justly derived services or property. Now, under the common law, the most important basis for enforcing a promise is because, quote, the promise was made as a part of a bargained for exchange. This requires that there be a manifestation of intent to be bound by the promisor, for which the promisee promises to do something in return for the promise. And again, I'm quoting Contracts in a Nutshell there. So in legalese, this agreement is called mutual assent, which is composed of both legally recognizable offers and the corresponding acceptance of those offers. But it is not merely mutual assent that creates a legally enforceable contract. The parties also need what is called consideration and the absence of a defense to contract formation, both of which we will get into. And as I'm reading this now, I just realized that I didn't talk about consideration. Consideration is basically evidencing that both sides are giving something up and receiving something in exchange. We'll see that the Constitution is fundamentally invalid without talking about consideration, but that's just what consideration means. So if any of these components are insufficient, the contract is unenforceable. And the reason why contracts need to live up to these objective standards is because if a disagreement arises, a third party must be able to objectively determine what the agreement was, or if there even was an agreement, before it can be determined whether the agreement was breached, and if so, what the proper remedy would be. But before we apply the legal contractual principles to the Constitution, I want to make it clear that every term that I've mentioned so far, mutual assent, offer, acceptance, consideration, and contract defenses, can only really be defined by the body of common law that supports them. Happily for us, as we start to define these terms, it becomes self-evident that the Constitution does not even come close to creating a legally enforceable contract that would be recognized in the private sphere. Generally speaking, and I'm quoting Contracts in a Nutshell here again, an offer is, quote, a communication that creates in the offeree the power to form a contract by an appropriate acceptance. In order for an offer to be legitimate, it needs three things. 1, it must be more than just a negotiation. 2, it must contain certain indefinite terms. And 3, it must be properly communicated to the offeree. In order to delineate offers from a mere negotiation or an invitation to deal, we look at the language used in the document, prior relationships, and other surrounding circumstances. Specifically, we are looking for objective proof that the parties are manifesting intent to be bound by their offer. In order to determine if terms are definite and certain, the offer must identify the offeree or class of offerees and must not be so vague in its terminology that a court could not objectively determine what is meant. To evaluate both those points, I don't know if any court could look at the terms necessary and proper or general welfare and arrive at an honest interpretation of what those terms mean. If the Constitution were a commercial contract that was breached, a court could very well find that these terms are too vague to enforce. If the Constitution is a contract, the offerees, which are the ones receiving the offer, would be, quote, "we the people," as stated in the preamble. This terminology is not very specific and would never fly in the private sphere. And as Lysander Spooner states, quote, "it cannot be said that the Constitution formed, quote, the people of the United States for all time into a corporation. It does not speak of, quote, the people as a corporation, but as individuals. A corporation does not describe itself as we, nor as people, not as ourselves, nor does a corporation in legal language have any posterity. It supposed itself to have and speaks of itself as having perpetual existence as a single individuality. This doesn't make sense in the legal sphere." And as Mr. Spooner points out, the language of the Constitution does not even attempt to bind the posterity of those then existing. It merely expresses, quote, that their hopes and motives in adopting it were that it might prove useful to their posterity as well as to themselves by promoting their union, safety, tranquility, liberty, etc. So here too I've demonstrated that the Constitution does not comport with established legal principles behind contract formation. In fact, the Constitution fails miserably on each and every necessary element behind contract formation. And as I have said, a contract may fail on only one single element in order to be unenforceable. But to recap, in order to form a legally enforceable contract, the contract needs 1, a valid offer, 2, a valid acceptance of said offer, and 3, no defenses to contract formation. If we examine the Constitution as a contract, the offer is invalid because 1, it contains vague terms, 2, it was poorly communicated, at least to a degree that would be acceptable in the private sphere, 3, it was offered to a poorly defined set of offerees, and 4, you could even argue that the offerors are similarly poorly defined. So what constitutes acceptance? Because we need offer acceptance to equal mutual assent. Well, for one, the accepting party must have the power to accept the contract's terms. The conventional wisdom says that acceptance of the Constitution happened when the state legislatures ratified it independently, but we've seen above that political representatives do not come close to comporting with the stringent degree of representation that the private sphere demands, so we can just throw acceptance out the window. And finally, we have defenses to contract formation, and while there are many, for the interest of shortening this already longer than expected podcast, I'm just going to say that coercion and incompetence are two of the biggest in a long line of defenses to contract formation. Obviously, not every individual then existing in the early United States was competent to bind themselves or their posterity to the Constitution as a contract, or those people didn't even have the power to do so, as Mr. Spooner explains. Moreover, by definition, the notion that the Constitution was ratified with the consent of every individual in the United States is rather comical. So ultimately, in supplementing the Constitution of No Authority, I wanted to take the Constitution and subject it to the same strict legal scrutiny with which we would examine any other legal arrangement within the private sphere. It is not a law. The Constitution is not a law because its own theory of sovereignty is violated through its ratification process. Moreover, the style of representation it relied on to secure its passage also fails when compared to the stringent legal obligations of agency and representation legally recognized in the private sphere to which we are resigned. Moreover, the Constitution is not a valid contract because it fails to satisfy even the most basic elements of contract formation. So there you have it. The Constitution has no authority. And I'm glad I've solved this problem once and for all. But I would encourage everyone in the audience, please do reference my source material to learn a little bit about how contracts actually work in the legal world, and please use it in your arguments. It seriously is foolproof, in my opinion. just this realization that just as the non-aggression principle fails to disappear when we form political entities, there should be no special magic that suddenly dissolves foundational legal principles when one departs from the private sphere and enters the political sphere. It just doesn't make any sense. Why have this double standard? So just as we are closing up here, if you find the work that we do here valuable, I would urge you all to please head over to our Patreon page at patreon.com/Liberty Weekly in order to support us and to get better access to the show. In addition, I would urge all my listeners to sign up for our email list where you will receive our free ebooks and personalized content updates from me. Also, I don't want the listeners to forget that we have our SpeakPipe voicemail app on our homepage. I did get a message from Trevor, and I apologize, Trevor. I haven't had a chance to listen to it yet and put it in this podcast episode, but it does work. It's collecting dust currently and cobwebs, waiting for you all to click on it and leave us some voicemail. So please do that. If this is your first time listening to the Liberty Weekly podcast, please check out our Patreon. Please also be sure to subscribe, rate, and review us on iTunes, Stitcher, or Google Play Music. Or better yet, please tell a friend about the show, because podcasts like these spread primarily through word of mouth. And I hope that you all found these arguments convincing. I certainly love talking about this topic, and if I had a little more time, I think I would have been able to make my arguments a little more organized and coherent. I apologize if I threw around too much legalese. You can find these terms defined on the internet if you need to figure out more about them. But I would reference the source material. And if you have any suggestions or critiques or would like to argue a little bit, please get in touch with me. You can do so on Facebook by liking our Facebook page at facebook.com/Liberty Weekly, or you can send me email directly at patrick.mcfarlane@libertyweekly.net. And again, my apologies. I almost forgot to mention that please do, if you value the work that we do here, navigate to our Patreon page and become our Patreon. You can find it by navigating to www.patreon.com/Liberty Weekly. Thank you. So as always, everyone, thank you so much for listening, and we will see you next time.
The Liberty Weekly podcast is brought to you by Tom Wood's Liberty Classroom. Sick of losing arguments with your statist friends? Fear no more. Now you can vanquish your intellectual foes with courses taught by top libertarian professors. Tool your intellectual arsenal and enroll today by navigating to www.libertyweekly.net/Liberty Classroom or by following the link in the show notes page.